Good morning, everybody. Good evening, good afternoon, good everything. My name is Jason Weiss, and I am the host of the Ask Jason Weiss show. Before we get started, like I always do every time I host one of these shows, although I am an attorney and although my guest today is an attorney, nothing that we say is to be deemed legal advice. This is just generic. You haven't hired any one of us. Should you seek legal advice or financial advice, or in this case, some bankruptcy advice, consult an attorney directly. There is no attorney-client privilege here. And again, nothing today is legal advice. So with all of that wonderful stuff said, and got all the stuff out of the way, today we have with us Adrienne Woods, who is a partner hang on, let me get the full name of the firm. You know how these firms are. At Weinberg, I apologize. She's a
Zareh.
partner of Weinberg, Zareh, Malkin, and Price. And if you're one of those people, you will, of course, want your name to be said correct. And she leads the firm's restructuring and creditors' rights practice, where she comes up with some legal and innovative and strategic ways to help clients meet their business goals. She's been doing this for 20 years. She handles bankruptcies in 7s, 11s, and 13s, and we'll talk about what those are. And everything having to do with bankruptcy to buying assets to getting things out of an asset sale to all of these various different things. And we have a fun little task and a fun agenda for today. So without further ado, Adrienne Woods.
Hi, Jason. Thank you so much for having me on today. Really appreciate the opportunity to speak to your viewers.
I appreciate it, and that is great. So where are you physically based out of? What state?
New York, and I live in Manhattan.
Okay, and are you only practicing bankruptcy in New York, or are there other places that you're allowed?
So I am only barred in New York, and specifically in the southern and the eastern districts of New York. New York's a pretty big state, and if you require an in-person appearance for something or other, you don't want to have to go up to Utica if you live in Manhattan. So.
Yep. Like me in South Florida, right? I don't want to go to Tallahassee or Jacksonville for a hearing when I'm down here in South Florida. So we get it. So a little bit what I threw out during the quick introduction was that we're going to talk about, I mentioned chapter 7, 11, and 13. Now, when the normal everyday person, even like myself, goes ahead and hears a little bit about bankruptcy, the first thing that we think of is, oh my God, they're closing their doors, they're not paying their bills, they're walking away. Now, that is not every type of bankruptcy, correct?
That's correct. So there are actually a lot of different kinds of bankruptcy. So we have, chapter 7, which you described pretty accurately right now, which applies to individuals and businesses, and it's liquidation bankruptcy. Basically, it means that a trustee is put in place, they sell everything that's not exempt, money goes to your creditors, but you're done. You walk away, you're finished. Then we have chapter 13, which is, think about it as reorganization for your middle-class neighbor. So they make some money, they don't make a ton of money, but this allows them to file a plan and reorganize their debts over a period of 3 to 5 years. They make payments of their net disposable income. And then at the end of that period of time, what they're not able to pay for the most part, caveat obviously, is forgiven. And then there's chapter 11 bankruptcy, which applies to individuals as well as businesses. 13, by the way, is just individuals. 11 can apply to individuals as well as businesses. It's for high net worth individuals. Think Mike Tyson or Left Eye Lopez or, insert wealthy person here who wants to reorganize their debts. And that's the individual side. For the business side, it can be anything from the big businesses that you read about. So think Enron, or it can be small businesses. Your neighborhood restaurant, around the corner that might have some problems paying their bills. And then that leads us to a sort of branch of Chapter 11, which is called Subchapter 5 of Chapter 11, which is specifically designed for small businesses and individuals with primarily business debt. And it's for people who don't really qualify for a 13. They could potentially do a Subchapter 5. For businesses that don't have, currently the ceiling is 3.024 in debt. Yeah, I know it's a random number.
3.024 in debt. What does that mean? I'm like, I'd never heard that before. I'm thinking 3.14 da 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 is pi, but
Right.
3. Yeah, I don't know
Slightly less than pi.
Yeah.
Yeah, I know it's very random, and that number does change. During the pandemic, it was actually increased to $7.5 million. It was extended another period. It was a 1-year extension, and then it was extended another year, and then unfortunately, although it was a bipartisan bill, one individual who we will not name blocked that from being voted on. And as a result, we reverted back to the 3.024 number. Why is this problematic? Because your average small business in New York has more than $3.024 million in debt. But a lot of them can't afford a traditional Chapter 11. So it really does, cut out the opportunity for a lot of small businesses that are viable going concerns. But going back to bankruptcies in general, there are other kinds of bankruptcies. There's a bankruptcy specifically for, believe it or not, farmers and fishermen. That would be Chapter 12. There's one for municipalities, Chapter 9. There's one for international recognition of international bankruptcies, Chapter 15. So, there are a whole bunch of different ones that your average person is never going to have to think about. So I thought it made sense to kind of focus on the ones that your listeners are probably going to care the most about.
So I know that I've gotten pre-show questions that came in from one or two clients and listeners. So one of them is, and I guess, this is more of a statement than a question. When somebody is going through a foreclosure of their home and don't want to lose their home, which is the avenue that they would normally go to? And I don't want to even guess. I know what my guess is, but so somebody that's in foreclosure, they want to keep their house. What's usually the chapter that they would try for?
Well, okay, so it really depends on what your financial situation is and which chapter you qualify for. Okay. So a Chapter 7 bankruptcy, to qualify in general, if you're an individual, since we're talking about a home, you have to have at or below the median income for your state, and it's relatively low in New York. It varies depending on the size of the household. Everybody's income is taken into account. So if dad files for bankruptcy, mom does not file for bankruptcy, their incomes both still count towards that household median income.
Gotcha.
Then, the number of children, obviously, the number of dependents comes into play. Any, adult children that may have special needs would be counted potentially as well. There are mitigating circumstances. So, there are ways that we can give a little bit of wiggle room. But for the most part, the means test is a fairly strict test. It was actually put into place during the bankruptcy amendments back in 2007. And it was put into place ostensibly to prevent bankruptcy fraud. In reality, most people who file for bankruptcy are not fraudsters. They're people that had bad things happen to them. And in much the same way that you don't blame the person who gets hit by a car crossing the street, you shouldn't blame somebody for filing bankruptcy.
Correct. And I think some of the stigma or the blame is away. And that's where my second question that came in, and I was actually speaking to a client about it this morning. The client asked me that, if he is contemplating file bankruptcy for his business, how does that affect him in his personal capacity?
Good question. Because Is it a small business, I'm guessing?
Uh,
Like a closely held corporation kind of thing?
yeah, like
Yeah.
one or two partners,
Mhm.
in a business, small, not like a Coca-Cola type company, but
Okay.
also not a mom and pop.
Hmm.
Probably did in its heyday 9 to 10 million a year.
Yep. Okay, so depending on the size of the business and depending on the amount of assets that the business has, banks may or may not require the principals of the business to personally guarantee the debt. So, if you personally guarantee the debt, filing a business bankruptcy will not absolve the individuals of their obligations. However, the individuals can also file for bankruptcy to deal with those debts. And the business and the individual may file for vastly different kinds of bankruptcy protection. So, I'm sorry, we might have a guest coming on.
I hear a puppy.
You do. You hear,
Oh, definitely. We are a dog friendly show and a
you
dog
hear a
friendly.
Bentley.
Ah, so yeah. Hi,
So
Bentley.
he wanted his moment in the sun. So
Hi,
here you are.
Bentley. Great to have you on the show. I'm so excited to be here with you, and we love the guests. That's all great. So mommy was talking to us about different types of bankruptcies for a small business. There are no personal guarantees in this. It's just straight up the business failed. The business
Okay.
is no longer there. COVID started the
Yeah.
trend downwards, and they just never recovered. Um,
Yeah. What kind of business was it?
in the culinary and food industry, a restaurant.
Mm. Yeah, they got hit very hard, as everyone knows. So okay, it already the business is already done. They're not looking to revive it.
They're not looking to revive it, but they're still there. They're operating, just trying to make ends meet now to the point that they're coming out of their own pocket. They had to lay off some staff. So I said, what are you thinking about doing? Can you
Hmm.
renegotiate your lease with the landlord? Nope. Can you, go ahead and work with some of your suppliers? Nope. They told me
Mm.
they even tried a 50-cent surcharge on eggs and all of this, and they can't do it. So I
Yeah.
said, well, you might want to think about bankruptcy.
So I could see two options actually. So they could just decide that they don't want to deal with it anymore and do a Chapter 7, liquidate everything and walk away. Or they might want to consider if they do want to keep the business going, because it sounds like they haven't stopped operating. It
Correct.
sounds like they're still looking to potentially make a go of this on some level.
Well, the fear that they have was twofold.
Hmm.
Well, threefold, really. The first one was, oh my God, how can I file bankruptcy?
Mm.
We don't believe in that and all of that. Number two was, okay, if we close down the shop and I file for bankruptcy, I'll never be able to get a loan or do
Hmm.
anything ever again.
Yeah.
And the third one was, look, we can't keep working 24/7 at this place and not even be able to pay our bills.
Yeah.
And, I've maxed out credit cards. I've done all this. I've laid off staff. I'm working. My kids are working. And I'm like, yeah.
Right.
So I said, you got to get a bankruptcy attorney. This is in Florida. Get a bankruptcy attorney in Florida.
And frankly, the sooner the better.
Yeah.
Because if you have some money to restructure, then you can still restructure. And I'll explain that a little bit. So, first of all, people who say they don't believe in bankruptcy, they should check out Title 11 of the United States Code. It's a thing, it exists, right? It's not like Santa Claus, we don't have to prove it. And it exists for a very good reason. It's actually one of the original components of our Constitution. People like to focus a lot on the amendments to the Constitution these days, but they miss the point that bankruptcy is actually a core component. It was understood that without a bankruptcy system, this country wouldn't be able to progress, right? If people aren't willing to take calculated risks, if they're afraid of debtors' prison, which is one of the reasons why this country was founded, then they're not going to take calculated risks, and they're not going to be willing to do the things that need to be done to create progress, right? So there's actually a phrase, and I'm going to mangle this, but the state shall create a uniform system for the forgiveness of debt. And so, our forefathers understood that. It shouldn't be a mystery to us. Only one out of every four small businesses actually survives. But do we want people to stop taking risks? No, that wouldn't be good. So the next thing is, well, how do I deal with all of this debt? So you said that the debt load was around how much?
Oh, I didn't say. I'm not
didn't.
sure. I'm not sure what the debt load is. I just know that, they are going into their own personal savings on a monthly basis to make the business survive. I know they've maxed out a handful of credit cards, and I actually am starting to defend some of the lawsuits that are coming in from the various credit card companies and, all of that. There's no SBA loans. There's no, there's none of that. It was just completely done on their own. They opened it up. They were doing phenomenal for years and years and years. And the pandemic hit and never, it's funny. They saw a little bit of uptick and they're like, we're going to make it. We're going to make it. We're going to make it. Yeah. And then I think with the price of food and eggs and everything else and the price of labor and getting good help and Uber Eats and delivery dudes whacking you with fees and screwing up your orders. Yeah. What the momentum they gained, they've, and they have two options: either go get a HELOC, which is a home equity line of credit, and use equity from their home and put it into the business, which I said I don't, or trying to find a buyer of the business. No one wants it. Yeah. They asked the landlord if they could reduce the rent or if the landlord would terminate the lease early, and the landlord said, not only am I not going to terminate the lease early, but remember, we abated rent during COVID, so we're going to look for all of that. But there is zero personal guarantee on anything except having to do with their credit card processing, where they hold some money out, and that's what the bank. And we're already working on that.
Okay, so the important component here is going to be to figure out what their total debt load is. If it is under the magic 3.024 number, right, which I'm really hopeful that now that, the election cycle is over, look, during an election cycle, no one, I don't care if you're a Republican, a Democrat, or something else, nobody wants to play nice, right? So there's not going to be any bipartisanship during an election cycle. However, now that the election is over, I would hope that the current administration, does the right thing and increases that debt limit again, so that it's more inclusive for most small businesses. But in any event, if they are below the 3.024 number, they sound like a great candidate for a subchapter 5 bankruptcy. So, traditional Chapter 11, you file for bankruptcy. You are what is called a debtor in possession. Means you get to continue to run the show as the show moves along. You operate your business, you pay yourself, you pay your employees, you deal with vendors. Nothing really different happens. In a subchapter 5, it is much the same, with a few critical differences. First of all, in a traditional Chapter 11, there is a presumption that there's going to be a creditors committee appointed. The creditors committee creates a significant expense for the debtor's estate because they're required to pay for the debtor, for the counsel, as well as any financial advisors or other professionals that are requested, right? In addition, you have to pay U.S. trustee quarterly fees. In addition to that, you need to get an impaired, and this is usually the toughest one, an impaired class of creditors to vote for or against, to vote in favor of the plan, right? And if you don't, then you can't confirm a plan. If you can't confirm a plan, then your case gets converted or dismissed.
It sounds like they want to kick you when you're down, that whole thing. It's like, hey, we know you have no money. We know you're suffering, but here's everything that you pay in order to do it. And real quick, before you enter into any of these, of course, if someone hires an attorney, you have to pay your attorney, correct? On a 7, 11, and a 13,
you do
pay your attorney. So you have to come up with those fees in advance.
You have to come up with all of the fees in the case of Chapter 7, because much like your debts to everyone else, your debts to your attorneys are forgiven once you file that petition, right? And I want to remind everyone, we are speaking in generalities here.
Generalities. This is not, I haven't given you a name of the client. I haven't done anything. And that's why I'm directing this to make sure it's non-generalities. And the best thing here is I'll get a little bit of education. And even if we wanted to, because they're based out of Florida, you couldn't do it. So
couldn't do it.
I'm not worried.
I mean,
So
I
we're
could pro honk in, but it wouldn't
there,
make sense.
exactly. But no, I actually know an attorney or two down here in South Florida that they will meet with based on the recommendations. But I guess the question I have, and we're going to go to break in a minute, but while you're on break, I want to throw out this tough question, and I'll let you get back to what you were doing. But when we get back, what happens to someone like, let's say you as the attorney who gets paid and they file bankruptcy, or let's say, they pay one of their vendors like they're supposed to,
right?
Bankruptcy trustee gets appointed. Is there a fear that money is going to be clawed back or taken back for that vendor? And is there some sort of, well, if you're a vendor that just got paid by somebody from bankruptcy, you might want to keep in mind, without giving legal advice, that you're going to get that money back. Is that, because that's something that was the last question that the client did ask me about vendors. So
clawbacks are a thing.
Yep. So what we're going to do is I'm going to leave everybody with this cliffhanger about what the heck's a cliffhanger? What the heck's a clawback? We're going to start with clawbacks, and then we're going to run back in, and then we're going to talk about, any trends you saw pre-COVID, post-COVID, and now post-election. So we're going to run to a quick break. Thank you for our sponsors, and we'll be back in 30 seconds. And we are back. And again, I am Jason Weiss. I am your host of the Ask Jason Weiss show. Although I am an attorney and have a guest of an attorney, nothing today is legal advice. We're talking hypotheticals, what ifs, scenarios, and this is all for educational and entertainment purpose only. If you want legal advice, financial advice, you want an attorney, you want attorney-client privilege, or you want to file bankruptcy in New York, then go ahead and reach out. But until you do that, no attorney-client privilege has been, and this is not any type of marketing or advertising. We are here having fun. So speaking of fun, Adrienne, we were talking about clawbacks. So real quick, for the listeners that don't know, what is a clawback? And if you are a individual or a business, I don't know if there's differentiations, and you were paid by someone who then enters bankruptcy, what happens? So
this is a very big question. So I'm going to try to summarize it into very easy bullet points. So clawbacks, yes, they are a thing. They are covered under Section 550 of the Bankruptcy Code. They allow a trustee or a debtor in possession to claw back or take back certain amounts that were paid prior to and sometimes after the petition date to anyone, right? Just making it very general. So they fall under a few different categories. First would be what we call a preference action. Preference being a word basically describing, we're concerned that you, debtor, might have preferred this person over other creditors, right? You paid them within the 90 days before the petition date. And we're going to assume that you preferred them, and we're going to make a number of other assumptions. So in order for it to be a preference action, it's a payment on account of an antecedent debt that allows the recipient to receive more than they otherwise would have received in a Chapter 7 liquidation. So it's a lot.
So it's basically you're playing favorites to this one because it's someone that's a friend or someone that this or someone like that.
Or it could be less nefarious than that. It could just be, this is a vendor that I'm really worried is going to stop selling me stuff and my business relies on it.
Or the oldest debt, right? This is the first vendor that I owed money to, and I just got a little bit of money in here, and I want to pay that person.
Or the squeaky wheel gets the oil. They sent you a few dunning letters. You got nervous. You don't want to be sued.
Yep. And that's always the fear, right?
Right.
Getting sued. And I know you can't give legal advice, and I don't want you to give legal advice, and we're going to stay on that theme.
Yeah.
I know that, the questions have come to me saying, well, if I'm going to file bankruptcy anyway, can I go ahead and use the credit card to buy that RV that I wanted? And I'm like, no, absolutely not. I said, and please correct me if I'm wrong, in the generality sense, if you keep it basically consistent, you pay your phone bill, you pay your electric bill, you pay your whatever. Look, if you had to buy a new phone because your phone broke, okay, the court's going to understand that. But if your car broke down and you need to go buy yourself a new car, don't buy yourself a Lamborghini. If you're replacing a Toyota Camry, buy another Camry or buy a Honda Accord or something similar, because the court doesn't want to. You don't want to raise red flags with the court.
You don't want to look like you're abusing the bankruptcy system. I mean, I put it as, okay, so if you are a creditor of yourself, how would you feel about this purchase? Would you be angry? Well, if you see somebody who had heretofore driven a Subaru and all of a sudden they're driving around and I'm not even going to go Lamborghini, I'm going to go Volvo.
Right.
Do you have any business spending more money than you have?
Correct.
No, you don't.
Correct.
But I found 99% of the people that come to me are not those people. They're really not.
Yeah.
They wouldn't even think to do that. And I do have to ask, have you bought, when I work with someone, I always have to ask, have you spent any money on extravagant purchases? And I'll tell you a funny story. Reason why you have to ask is because what you and I consider an extravagant purchase may not be what someone else considers an extravagant purchase. So I had a call a while ago with a gentleman who, and this is vague enough, I can tell you all the funny details.
Okay.
So he was going to file for bankruptcy, and he had already booked his family's vacation, but he assured me, don't worry, it's a very simple vacation. He's only spending, $10,000 to take the kids upstate for a week. Well, $10,000 is a lot of money to your creditors. Yeah. So if you tell me that you're taking your kids to Seven Flags for a few days and it was already booked, okay, I'm not gonna, nobody's really gonna go nuts over that. But if you haven't booked it yet, don't hold off. But if you're booking something that you can't afford, don't. Full stop.
Yeah, and that's what you've got to do, and you got to just make sure that, again, I always tell the clients that are contemplating or thinking about it, stay even keeled. Don't give them a reason to want to sniff around any longer and to want to see it, because, and right or wrong, I tell them that, look, the trustee's job is to find money because the trustee gets paid from money that is found. For the listeners that don't know what a trustee is, can you explain A, what a trustee is, and B, how a trustee gets paid, and C, how a trustee could possibly get your case or is selected? How does that whole selection process work?
So the trusteeship is a panel position. You apply to become a trustee. And to be honest with you, I've never gone through the process. I have zero interest in being a trustee. It's just not where my head's at. But essentially their job is, once they get appointed, they sit at the 341 meeting, they review your petition, they review your schedules, and they ask you questions. And a lot of the questions they're going to ask you were already answered on your petition, but they are frankly looking to trip you up. They want to know, okay, you said you don't own any real property, but do you? You said you don't own any companies, but what about these shells that we found when we researched you on the internet? What about these companies? And what do they own? And what's your percentage interest? And they will drill down on it. So I always tell people, be as forthright as you possibly can be. Err on the side of being over-inclusive. If you had a company, 5 years ago, and it's, it's a shell company. You never did anything with it, and you don't intend to list it. It is no harm. But once they research you on the internet, and the good ones do, and some of the bad ones do as well, they will find everything. And if they find something that you left out, God help you, because this will drag on forever. Right.
Yep.
Even if it's inadvertent, by the way. So, that's why a lot of times I hate filing emergency petitions. There should be a back and forth process where we go over that petition, we look at that petition, and we have heart-to-heart conversations about making sure everything is correct, accurate. And I remind my clients, you're signing something under penalty of perjury. This is not a joke. $500,000 worth of fines and up to 20 years in prison, not worth it.
And it's funny, you could try to hide the stuff, and there is some
people can.
Right, and there's a performer out there whose name is Daniel Hernandez. You can read this on the the news feed or Google or whatever you want. Who's also known as Tekshi69 or Takesha69 is an American rapper, and has these IRS judgments against him. And the IRS has seized his Lamborghini and seized his Bentley, is seizing all of the jewelry that this man was wearing around his neck. It was like a diamond shark and this and that. And they're selling them all to make the IRS whole, because the IRS says, we don't care what you file. We're still going to get our money. We're owed our money. So same thing. Basically, in bankruptcy, you need to remember that the trustee is not your friend. The trustee is not there to harm you, but the trustee is there to do what's right. It is basically how it is. And look, usually people in bankruptcy, they feel terrible, right? I can't afford it. I didn't make it. I can't pay these people.
Yep.
The flip side is, why should you have to suffer the rest of your life to take care of this debt when the government allows you to use this? And that's where we're at.
Right.
Now, with all of that said, COVID was, we all know, it was a rough time. I can't believe it was, already 5 years ago, 4 years ago, depending. I know that the government tried to do a lot for people during COVID. But, like I said, with the restaurant client that just can't recover.
It was a pandemic. I mean,
it was,
it was kind of a new thing.
And so have you seen, so since I guess we're done with COVID, right? I mean, kind of.
I don't know. I'm actually recovering from COVID right now. I don't know if you caught this, but my voice is terrible.
I knew you weren't feeling 100%, and we talked about it. But I mean, if this is you at 80%, I can't imagine what you would be like at 100%. So then let's make. There's basically two spots I want to see. Since COVID, what have you noticed? And then and I know we're only not even 30 days into it with the new administration. If you had a crystal ball, where do you think things are going?
I am going to address the policies.
Fair enough. I don't want politics. I just look. You can open up your browser and you will see that Trump has cut federal funding. Trump is coming with new programs, new orders, new things. Right? It's regardless of political affiliation. January 20.
If anyone were to do this, this is what would happen. Right.
So it's January 2020 was his first day in office, and we now have for the next 4 years certain policies, certain ways that are going.
Yep. Look, I am happy to help Democrats, Republicans, conservatives, liberals, libertarians. As long as you're an honest person and you can pay my bill, we'll talk. Okay. But I can tell you that some of the policies.
Pay your bill. Is your bill subject to that clawback as well?
No, my bill is not subject to that clawback.
And is that because you get paid like in full up front, or do you get paid as part of the plan? So
the way it works is this. For Chapter 7, you have to be paid in full prior to the filing, for the reason that we discussed, right? As soon as you file your petition, any prior debts, you don't owe them anymore, right? for the most part. And again, generalities. For a Chapter 11 bankruptcy, and Chapter 13 is a little more complicated, not worth getting into.
So we'll just talk about 7s and 11s.
Right. So for a Chapter 11 bankruptcy, I get a retainer up front. I work through that retainer up to the bankruptcy point. And then once we file, I can't use any more of that money without getting court permission. Now, the reason it's not subject to clawback is the retainer is paid and then I do the work, right?
Got it.
So there's no antecedent debt. So you can't have a preference if you don't have an antecedent debt.
Gotcha. Well, that's why bankruptcy attorneys and criminal attorneys, they want it up front. The criminal attorneys want their money up front because if you go to jail, you don't have access to your money. So, all right. So
that's fair. Yeah.
That makes a lot of sense and all of that. And before I let you get into the question, I was texted by one of my friends that asked me to ask you a question during the show. Mm-hmm. And it was, what if I have a business and send a bill to someone who's filed bankruptcy? What happens? So, okay, I get the question. So I'm an attorney, right? I have clients, and I send my client a bill because of the services that I have, and the client didn't pay the bill and files bankruptcy. Mm-hmm. I'm guessing, and I know this because I've experienced it, I get a notice in the mail saying that you're there. So as a business owner, and so we're talking, we'll use my business, what do I do?
Well, that question is actually twofold. So in your friend's mind, did he know that they filed for bankruptcy already? No,
he didn't. I'm going to guess no.
Because I was wondering if he was asking if that would violate the automatic stay, which is yes.
Correct. No, he said they wrote back saying we filed bankruptcy. And so
Chapter 7 or Chapter 11, and there's assets to be distributed, he'll be served with what's called a notice of bar date. And that'll tell him the date by which he needs to file a proof of claim. Claims bar dates are strict. If you miss it by a day, if you miss it by an hour, you generally cannot come back from that. So you definitely want to make sure you file the best you can. And I say the best you can because you also generally have a right to amend your proof of claim after the bar date.
Now, you mentioned something about an automatic stay.
Yes.
Explain that to the listeners. And that's the point I want to hear more about as well.
Okay. And this applies to a lot of things. This applies to your foreclosure question, actually, earlier in the show. Mm-hmm. So whenever an individual or a business files for bankruptcy, what's called the automatic stay kicks in, and it prevents anyone from taking any action to collect against the debtor, whether it's a business or an individual. Now, importantly, it does not save anyone who is an affiliate, anyone who is an owner, anyone who is a relative, a spouse. Only the person who actually, or the business who actually files, is protected by the automatic stay. You can get relief from the automatic stay to try to pursue your debtor in state court for various reasons. Can't really get into it in this show. It's far more complicated, but just know that it is a thing.
Okay. And if you go ahead and you knowingly know that somebody is in bankruptcy and you still try, you're, as the person sending that bill, going to get into trouble. So
you are
once
in trouble.
You know, you kind of like need to stop.
A knowing violation of the automatic stay is a big deal. You have essentially violated a court order.
And you don't want to do that, ladies and gentlemen. So the second someone says, I filed bankruptcy, that means that you stop, you don't send your bill anymore. You hire a bankruptcy attorney if it's worth it for you financially. If you're owed $100, probably not going to do it. If you're owed $100,000, you're probably going to want to hire an attorney. And if you're in New York, you want to hire Attorney Woods right here, and allow her to help you collect on that, because again, that's also something like we hear it all the time. Oh, I'm going to get nickels on the dollar or dimes on the dollar or pennies on the dollar. But if it makes sense to get pennies on the dollar and pay an attorney the fee, you got to make that decision. And that's why you should be consulting with someone like Attorney Woods.
And also, sometimes the difference between whether you get pennies or nickels on the dollar has to do with whether or not you hire an attorney who files your proof of claim correctly. Because if you file your proof of claim as a general unsecured claim because you didn't know that you had an administrative claim, guess what? You're getting paid as a general unsecured claimant because it's not the debtor's job to figure out that you misfiled your claim.
Right. The debtor is just, okay, it's there. These are the box they
Right.
checked, and this is how we're going to operate.
Right. And in larger cases, it's just practically impossible.
So when I interrupted you to talk about the automatic stay, and I will take it on the chin for that, I did it. We were talking about since COVID, and we'll make it a little change. Since COVID, what kind of have you seen changes in the bankruptcy court filings? Have you seen changes in how the courts are handling bankruptcy? So we'll do that. We'll make it a little more generic. What are the trends in bankruptcy as we sit here today? How's that?
Well, okay. So COVID resulted in an artificial manipulation of almost all of the things that lead to bankruptcy filings. So why do people file for bankruptcy? Well, they're being sued. Well, hey, it's COVID. The courts are closed. We're being sued. Oh, but wait, I have extra money. There's PPP money. There's idle money. There's enhanced unemployment insurance. So now maybe I can afford to pay my bills. I'm going to file for bankruptcy. Oh, wait, I don't have to. There's an eviction moratorium. They can't kick me out, even if I'm not paying my rent. There's a foreclosure moratorium. Haven't paid my mortgage in 2 years, but hey, can't kick me out.
Yep. Got another 18 months on top of that 2 years. Yep.
And banks were giving internal guidance not to call things bad debt for the somewhat obvious reason that they have obligations to maintain certain quotas with the regulatory authorities. And bad debt, when you call something bad debt or non-performing debt, it's not a binary. When somebody starts paying again, you can't say, oh, now it's a performing debt again, right? It's a performing asset again. No, it has to be paid off. So,
and there's a movie about that. I don't know if you're a movie person like I am. It's called The Big Short, and I actually just watched it.
I've heard of it. I've never watched it.
There are so many things that you can get from that movie. I don't own stock in it. I had nothing to do with it, so it's not a plug for the movie, but it's called The Big Short. It's got some phenomenal actors and actresses in it, and it talks about the mortgage foreclosure crisis and good debt and bad debt and how to rebook it. And there's also things in there with people that care about marketing, how they market and how they treat things. It's just a very well put together movie. So we're back to my interruption once again. And glad you're not a judge because I'd be sanctioned by now.
It depends on how entertainable the judges are.
Some
of them have a sense of humor.
Yes, but not a lot of the bankruptcy judges in Florida do. They're kind of straight shooters, which is good. That's what you want. So we were talking about that there were all of these things that the government, the state, and all these moratoriums that were put into place that allowed people to avoid bankruptcy or delay.
Yes.
Do you think?
Unfortunately, in a lot of cases, people were kicking the can down the road. If you can't afford to pay your rent for 8 months, and this is another thing that I think the government did in general that was really kind of unfair. They kind of left people hanging in terms of whether or not there was, I'm sure you guys had it in Florida too. Up here, there was this whole big push, rent forgiveness, mortgage forgiveness. And I don't want to talk down to the everyday person because the everyday person, they're good at what they do. But unfortunately, they don't think about the big financial picture for the most part, which is your landlord has to pay their mortgage.
Yep.
The bank has to maintain their quotas.
Yep.
What if your rent is forgiven or your mortgage is forgiven? Where does that leave these other actors? So a lot of people up here were pushing for rent forgiveness, mortgage forgiveness, forgive all the debt, but it's not feasible. Yeah. And the government never did the right thing, which is tell people, we can't forgive this. So people didn't pay their bills for a year, 18 months, and then all of a sudden they get hit with this bill and they're like, what the what?
Right.
What's this now?
Or it's we've extended your lease for the 18 months that you didn't pay it. Here it is. And oh, by the way, your rent's going up and we're going to charge you interest on top.
Right.
So we're almost out of time. We blew through this time.
I know.
So I think Silverio's down there. If you, Silverio or Cece, whoever's running it, if you could just run Adrienne's contact information below. It's A Woods, WOODS, A Woods, WOODS at W as in whiskey, Z as in zebra, M as in man, P as in plane, L as in lawyer, AW.com. So it's A Woods at WZMPlaw.com. Find her, ask questions about bankruptcy in New York, because that's where she can give you legal advice and that's where you can hire her for it. And you can also talk about things, how you don't get yourself in trouble trying to collect on a debt. Someone's in bankruptcy. You want to buy something at bankruptcy because it's at a great price. She will be able to help you. So there are so many things that can be done in a way that bankruptcy, is a beneficial, and it is not embarrassing. It is a tool. It is a mechanism, and it is available. And that's why Attorney Woods and many other people can practice in that area. So before we go, I usually ask the hardest question of the show. I save it for last, and we only have like 30 seconds to a minute. So the guest that we had on the show, Bentley, how old is he? What is he? And can we see him if he's on your lap?
This is Bentley. Say hi, Bentley.
Hi, Bentley.
Oh, don't be camera shy now.
Very cute.
Oh, there we go. Okay. Bentley was adopted right before Christmas of last year. And he was adopted at 8 weeks. So, he's a little over a year old now. And he is a hybrid. I adopt, I don't shop. Yep. And so I think he's a Chiweenie, because he kind of has like a little hound dog look to him, but he's Chihuahua-esque as well. And then what was the other question? You answered it. What was he? How long have you had him? How old is he? And can we see him? So that's it. So if you want to meet Bentley again, schedule a Zoom conference with Attorney Woods. And if you have bankruptcy related questions, it could be you're thinking about filing, someone owes you money, you don't know what to do, you don't know where the bankruptcy court is, reach out. Silverio, run it one more time on the bottom so I can read it one more time for the listeners that are only listening. A Woods at WZMPlaw.com. Tell her that you saw on the show, and she will give you 1 extra minute at no charge. So there's my humor, and I got to be careful because I don't want a bankruptcy court, taking back that 1 minute of her time. Consultations are actually free, by the way.
I let you put that in there. So consultations are free, but be respectful of people's time. That's all I ever say. So thank you so much for being on here. I feel like we could have gone in so much more, and I think we will. We'll schedule again to get you on the show, maybe in the next quarter or two.
I would love to.
Thank you, Silverio. Thank you, Cece. Thank you for the Going Bold Solo Network Radio. Thank you, everybody, and I will see you in 2 weeks. And special thank you to Bentley.
Thank you for having us.